Good afternoon and welcome everybody. My name is Donna Goldsworthy and I'm a partner in the dispute resolution team. Today the team is going to update you on developments in dispute resolution post-Brexit. We're going to look at some key points as follows. So governing law, is English law still a good choice? We think so. Service on EU counterparts post-Brexit and any problems you may encounter. Jurisdiction and enforcement. How will English jurisdiction clauses work post-Brexit? And what about enforcement of judgments in the EU 27 countries in the new landscape? We'll also talk about whether there are any alternatives or solutions we recommend in this new landscape. We have to remember previously that due to the EU regulations, we enjoyed a good degree of judicial cooperation between the EU 27 courts. That has now changed, so there are now a number of hoops you have to go through and things you need to think carefully about before embarking on litigation or drafting new contracts. This will add a layer of time and cost to proceedings, and it's something that you need to think carefully about with the clients. Before I hand over to the team, can I just say a few words on how the presentation works today and housekeeping? Everyone is on mute, but you'll have a chance to answer questions via the question box. We will moderate these at the end. We will also send you our slide deck, and at the end of the slides there are our contact details. So if you don't get the chance to ask your questions or you think of anything else, then please don't hesitate to contact us. We'd be delighted to help you. So without further ado, we'll move on to our presentation and over to Rebecca. Thank you, Rebecca.
Thank you, Donna. Hello, everyone. My name is Rebecca Smith, and I am an associate in the dispute resolution team here at Fieldfisher. So the short answer to the question whether or not English law is still a sensible choice when picking which governing law should govern your contract is that yes, it is still a sensible choice. As you may already know, before the end of the transition period, the rules around contractual and non-contractual obligations could be found in the Rome I and Rome II regulations. These were the two EU instruments which set out the rules on governing law of contractual and non-contractual obligations. These regulations included a provision which required EU member state courts to respect a party's choice of applicable law. Although those two regulations are no longer applicable within the UK, provisions from Rome I and Rome II have been incorporated into UK domestic law. Accordingly, going forward from the 1st of January 2021, we expect UK courts and EU member state courts to continue to uphold English and other applicable law governing law clauses in the same way as they did previously. So just moving on to the service of proceedings and how that has changed post-Brexit. So previously, the UK proceedings could be served on defendants in other EU states in accordance with the EU service regulation. Very briefly, this provided for various methods of service, including via post, through designated central bodies or direct service, and it was considered to be a fairly efficient and straightforward process. That service regulation is no longer applicable between the UK and EU member states. Therefore, the UK is unable to transmit documents for service or comply with requests made by other member states to serve within the UK in accordance with that regulation. Going forward, therefore, we'll need to think about what the alternative service regimes are. So claimants can firstly look to use the Hague Convention on the service abroad of judicial and extrajudicial documents in civil and commercial matters. This is more briefly known as the Hague Service Convention. So they'll be able to use this when effecting service on parties located within the EU and further afield, where that party state is signed up to the Hague Service Convention. Secondly, a claimant may wish to look whether there is any other treaty or convention currently in place between the UK and the receiving state. So the Foreign and Commonwealth Office Treaty Section and the Foreign Process Section of the Royal Courts of Justice in London are able to provide people with some useful information on whether a relevant treaty exists and how they can get hold of a copy. So where a country is a party to the Hague Convention and a separate service convention, they can technically pick which one they want to use. And then finally, one thing to consider is whether or not your contract has a provision which allows for the service upon nominated solicitors or another agent. If so, you won't need to spend your time and money serving documents pursuant to the Hague Service Convention, another treaty, or in accordance with common law, because it can be a fairly time-consuming and costly process. So now I'm going to hand you over to Nicola, who will take you through the enforcement of judgments.
Thanks, Rebecca. I'm Nicola Sewell. I'm a director in the dispute resolution team. As Rebecca says, I'm now going to talk about enforcement of judgments. For claims which have been commenced prior to the end of the transition period, i.e. before the end of 2020, a judgment can be enforced within the EU under the recast Brussels regulation as if it were a judgment of the member state in which it's being enforced. In other words, there are no additional hurdles in relation to recognition or enforcement within the EU country the judgment is being enforced, although the debtor can, in very limited circumstances, seek refusal of enforcement. So, at least in theory, enforcement should therefore be a relatively quick and not too costly process. The position for claims issued on the 1st of January onwards is going to be the law of the country it's being enforced in, the Hague Convention, and possibly down the line the Lugano Convention, but whether the UK can join that remains to be seen. There may also be bilateral treaties that are applicable. These are being dusted off as we speak, but thus far only Norway has affirmed a bilateral treaty. There may also be old law that assists. So, for example, in Cyprus, there is a law that predates the UK's membership and Cyprus' membership of the EU, which means that judgments can be enforced just following registration. It is also possible that an agreement will be reached in due course, so the UK enters an agreement akin to the recast Brussels regulation, but there's just no sign of that currently. So a bit more on the 2005 Hague Convention on Choice of Court Agreements. This applies as between the UK and the EU, Singapore, Mexico and Montenegro, but it doesn't apply to the EFTA countries. The scope of the Hague Convention is more limited than Brussels or Lugano and applies only to contractual disputes where there is an exclusive jurisdiction clause. So it does not apply to disputes arising from contracts with non-exclusive jurisdiction clauses or non-contractual disputes. And it also expressly excludes consumer, employment, insurance and company law matters. There are similar grounds for refusal to enforce as under Brussels, but with an additional criteria that the original court was actually designated under an exclusive jurisdiction clause. There is also an additional step. So a judgment needs to be recognised and a declaration of enforceability or registration obtained before enforcement. And the process that governs this is under the law of the enforcing state. The convention says that they are required to act expeditiously, but in practice, that may mean little. There is also some uncertainty about what the status of exclusive jurisdiction clauses entered into after the 1st of October 2015, when the Hague Convention came into force for the EU and therefore the UK, but prior to the date of the UK's accession in its own right will be, and whether they will be recognised by EU states. As mentioned on the first slide, in due course, the Lugano Convention may apply. The UK has applied to join it, but the EU must approve its membership, and it's not yet done so. It should indicate one way or the other by April, but even then, there would be a 3-month delay before the UK actually joins. But if Lugano does apply, then it would address the main issue with Hague, as it is not limited only to disputes under exclusive jurisdiction clauses. It's still not as straightforward as under Brussels, because it also requires an additional step. an application for enforcement in the relevant country needs to be made, and a declaration of enforceability obtained before the judgment can be enforced. The judgment debtor also gets an opportunity to appeal against the declaration, and no enforcement action can be taken during this period. So unless and until the UK is admitted to Lugano and where Hague does not apply, recognition and enforcement will rely upon the domestic law of the country in which the judgment is being enforced. This is currently the position vis-a-vis enforcement of English judgments in large parts of the world anyway, so it's not that it's something that's entirely new or unknown. There's also no reason to think that the EU states are going to stop recognising and enforcing UK judgments. A system of mutual recognition benefits them as well as it does us, and it really makes no sense for them to start rejecting judgments. But there will definitely be additional steps and some further costs compared with under the Brussels regime, in particular local lawyers' fees. But there are still many benefits to choosing English law and jurisdiction that outweigh the downsides, and I'll come on to discuss that in due course. But I will just hand over to Julia now.
Thanks, Nicola. I wanted to speak a little bit today about the implications of the removal of the Brussels regulation and the Lugano Convention to the approach of European courts and the English courts to jurisdiction clauses. And I think it's worth, in this context, actually looking at Article 25 of the Brussels recast regulation, which applied up until the end of last year. And the important thing about this is that it set a standard rule that was applied across courts of the EU member states as to the treatment of jurisdiction clauses, and whether if there was a dispute about jurisdiction, whether those clauses would be upheld. And in this case, and Article 25, as you can see, was mandatory. So it gave a great deal of consistency and predictability. Article 23 of the Lugano Convention, which is the equivalent provision, also was mandatory. So without that, there is now introduced a degree of uncertainty and unpredictability as to how jurisdiction clauses in English law contracts will be treated if they are disputed in other European courts, because England is no longer a court of a member state. So such clauses will not necessarily be upheld in the same way as they have in the past. Next slide, please. So broadly, if you have a plain vanilla exclusive jurisdiction clause, typical boilerplate approach, both parties submit to the exclusive jurisdiction of the English courts, and your contracting counterparty is an entity in another EU member state, that will be unproblematic because it should fall within the remit of the Hague 2005 Convention on Choice of Court Agreements. As Nicola has explained, however, the Hague Convention is not as wide-reaching as the Brussels regime because it's restricted in the range of contracts it covers. It doesn't cover Switzerland, Iceland, or Norway, and it doesn't extend to asymmetric or unilateral jurisdiction clauses. And we are already seeing queries or problems arising from asymmetric clauses. Just to explain these in a bit more detail, they're common in cross-border lending agreements. Typically, they provide for exclusive jurisdiction of the English courts, but then go on to state that that is for the benefit of the lender only, who is entitled to sue in any jurisdiction. And the idea is that the borrower must sue the lender in England, but the lender can sue in any jurisdiction where the borrower may have assets. Now, asymmetry has always been a problem in some jurisdictions, even under the Brussels recast regulation. The English courts are content to recognise them, as are, for instance, the courts of Germany, but the French courts have ruled on a number of occasions that such clauses are invalid. Without the Brussels recast regulation, the question of whether such clauses will be upheld is now a matter of national law. So again, you're going to see unpredictable outcomes, particularly in the immediate future. There are also implications for the English court's approach to asymmetric jurisdiction clauses that provide for English jurisdiction in contracts with non-EU counterparties. The wording of Article 25 provided that it was applied wherever a nominated court was a court of a member state. And as the UK no longer is a member state, the English courts no longer have the Article 25 precedents, which we've seen over the last 10-20 years, on which to base their decisions. They'll have to go back to common law principles when deciding whether to uphold asymmetric jurisdictions clauses. And while I'm optimistic that the English courts will uphold asymmetric clauses, you can imagine enterprising debtors having a pop a jurisdictional challenge by challenging the jurisdiction clause itself. However, to tip the balance slightly in favour of the claimant, there has been a change to the civil procedure rules, so there is no need to make an application for permission to serve out of the jurisdiction in a contractual dispute where there is a valid jurisdiction clause. It doesn't mean they can't be subject to challenge later down the line, but it does mean that it isn't the primary decision that the court will have to make at the beginning of a dispute. Next slide, please. Yes, so Lugano, why is this important? Well, it would help a great deal because it's similar to the Brussels recast regulation, but it isn't entirely the same. For example, there's no equivalent to Article 31 of the Brussels recast regulation, which provides that where you've got an exclusive jurisdiction clause, another court that's where competing proceedings have been started up has to stay those proceedings. It will now be a matter of discretion based on national law in those courts, whether they decide to decline jurisdiction in those circumstances. So broadly, there's overall potential for satellite jurisdiction clauses in cross-border contractual disputes wherever the Hague 2005 doesn't apply. And so we could see the return of what is known as the Italian torpedo, where one party deliberately starts up proceedings in an unhelpful jurisdiction in order to try and defeat a contractual claim. And I'll hand back to Nicola. Thank you.
Thank you, Julia. So this slide is really a reference guide that we've put together regarding enforcement, and we hope that it will be useful. You'll get it in the slide pack, but hopefully will help you wade through all the various different potential routes for enforcement. I'm just going to now touch upon what are some of the alternatives and solutions going forwards. One of the most obvious is arbitration. Brexit has not impacted the rules on arbitration or the enforceability of arbitration awards. There are 157 signatories to the New York Convention, and that includes all 27 EU member states. But having said that, traditional arbitration may not be appropriate for all types of disputes. And in the future, you may need more sophisticated arbitration clauses that capture different types of arbitration for different values of dispute, for example. There are also obviously alternative jurisdictions to England. However, most of the EU have civil law systems, which have much more rigid and inflexible rules than our common law system. There has been a move by certain countries, in particular France, Belgium, Germany and the Netherlands, to set up specialised commercial courts that will hear proceedings in English and that will apply foreign law. But these again are not directly equivalent. There are some issues. For example, procedural documents have to be submitted in French in the Paris Commercial Court, and the Dutch civil procedural law, which is known to be complex and prone to delays, will apply to proceedings in the Netherlands Commercial Court. There is also a big question about how they will apply English common law, which is likely to be a matter of expert evidence before them, and the court then decides which of that expert evidence it prefers. So potentially the largest and most obvious alternative common law jurisdiction, which remains in the EU, is Ireland. But again, there are potential issues there. It doesn't have quite the same offering as England. There are a lot less judges and courts. There are also rules against certain funding arrangements, such as conditional fee agreements or damages-based agreements. These are only allowed in debt recovery or claims for liquidated sums, which is quite a limited category. There are still significant benefits to the English courts. They are transparent, flexible and impartial. Judges generally have many years' experience in dealing with international complex and high-value disputes. Under English law, judges are able to interpret and apply legal principles in a commercial way, and the law can adapt and evolve with the times. English courts are also experienced in hearing evidence in relation to and applying other laws. And English has been the lingua franca of international commerce and accordingly commercial disputes for a very long time. And just a word on boilerplate and standard dispute resolution clauses. Unfortunately, if there ever was, there is no longer a one-size-fits-all boilerplate clause. Parties are going to need to consider their litigation strategy going forwards, and points such as where the parties and their assets are actually based when deciding what to put in those jurisdiction and governing law clauses. Some alternatives have been mooted to just the kind of clause you find now. So, for example, a hybrid of English courts for some disputes and perhaps arbitration for others. But again, I mean, that looks a lot like a non-exclusive clause, and therefore there's obviously a risk that you would fall outside of the Hague Convention. So I will just now hand back to Donna.
Thank you, Nicola. As you will appreciate, there's a huge change in the legislation. There's a myriad of rules to now look at before you strategize in litigation going forwards. But I thought it would be useful if we recap on some of the key points that pertain to contracts and the key things to remember. So in terms of governing law, there is some good news at least. We've heard that England and Wales as the governing law is still a good jurisdiction, governing law in a contract. That's been retained by Rome 1 and 2, so there's no change there. A drafting tip in terms of service of proceedings, which as you've heard, there may be issues to navigate. You can put in an agreement or put in the agreement an agent to accept service in the proceedings. That may help circumnavigate any of those issues. So we recommend that in some circumstances. You've also heard about jurisdiction. The main message now is one size does not fit all. If you're thinking of your new contracts, then you need to look at the exclusive jurisdiction clause in favour of the UK court, and that will be protected by virtue in most instances of Hague, the Hague 2005, which the UK rejoined as at the 1st of January 21. And we'd say that the UK courts remain a very good choice, well-respected judiciary globally. So those are things to bear in mind. In terms of your contract checker, if you could change slide, please. So what are the practical implications for all of this, and how does this translate into everyday work? So you really do need to look at your raison d'etre for choosing the governing law, and does it fit with your litigation strategy? What happens if it all goes wrong? And as we know, sometimes it does, hence litigation. You need to look at the commercial issues at play in terms of, do you have bargaining power? Can you get what you want? Can you possibly renegotiate your dispute resolution clause? And those are things you need to be thinking about. And thinking ahead to the worst case scenario, where are the assets? Where are the counterparties based? Are any of the conventions going to protect the case in terms of enforcement? And is it necessary to get local law? So I think these points underline the fact that a certain amount of thinking ahead strategy is very important in terms of thinking about litigation. Nicola also mentioned arbitration. As we've heard, that seems a good alternative and a safe bet at the moment. There is a degree of certainty. And we've seen an uptick in requests to look at arbitration clauses and clients actually putting those in at the last minute. The reason for that is I think there's been so much uncertainty, particularly with the transition, that a lot of people have actually wanted to put those in to avoid any uncertainty. And we have to remember that we've just gone through the transition phase. So therefore, if your claim was issued up until and proceedings served the 31st of December 20, then you're protected by the EU regulations. However, that's now finished and we're now into the new regime as at the 1st of January 21. So bearing all that in mind, now is a good time to take an audit of your contracts. You need to look at any litigation going forwards. Have you already issued proceedings? You could be looking at your existing contracts to check if there is a problem, which legislation will help. And in terms of drafting new contracts, looking at the Hague Convention with exclusive jurisdiction clauses. And if you've had a chance to look at our decision tree, you will see it just shows the myriad of decisions that need to be thought through before any agreed strategy is taken. So that pretty much brings us to the end of our presentation. We're going to look at the questions that have come in and moderate those. So if you bear with us for a moment, we'll get to those. But just looking, first question that's come in is on how the courts will view asymmetric clauses in litigation going forwards, and will that work? I think, Julia, that's one for you, if you can take that.
So there'll be two answers to that kind of question, which is, will they work in England, and will they work in the jurisdiction of the counterparty? And as I mentioned, in England, we're back to square one in terms of having authorities on which to rely. But looking at some previous analysis, as I said, I'm reasonably optimistic that we will, in the next few years, get some authorities and decisions from the English courts on which we can rely. I think the English courts are quite comfortable with the idea. With the European courts, that is going to be a question for them under their national laws, and this is where the unpredictability will be. So by way of an example, my colleagues were dealing with a banking transaction with a counterparty in Switzerland, and in that context they needed an opinion from Swiss lawyers as to the enforceability of the contract before it could be completed. And the Swiss lawyers came back and went, well, we can't give you an opinion because the UK is no longer a member of Lugano. So rather than say, no, we don't think it would be enforceable, we just don't want to give an opinion. And that was an asymmetric clause, and it was a fairly simple asymmetric clause, as I described in my talk earlier. In that case, after a bit of toing and froing, the parties in the end, I think, used an arbitration clause instead, a mutual arbitration clause, because arbitration awards are readily enforceable in Switzerland, and that got them over the hump of getting that Swiss law opinion. So I think they went in the end for arbitration under LCIA rules in London, which made it as London-centric as possible for them. But that's typical of the kind of query that we're getting in at the moment.
Thanks, Julia. We've had another question in about how arbitration will work and whether that process will be impacted by the new regime. And now we've exited the EU Brussels recast. Nicola, are you okay for that one?
Yeah. Yes, Donna. Yeah. As mentioned earlier, Brexit's had no impact on arbitration. So in terms of, if you get an arbitration award, will that be the enforcement of that be impacted in the same way as enforcement of English judgments? The answer is no. So you don't need to worry about that. But a slightly a connected question, I think, is should that mean you automatically switch over all of your jurisdiction clauses to arbitration because of the concerns about enforcement of judgments? And I would just say you need to be a bit cautious about that, because in the same way as exclusive jurisdiction clauses, there is no longer a one size fits all. I also don't think that you can say there's a one size fits all arbitration clause for all types of contracts and all types of disputes. So I think enforcement should not be the only consideration in the decision. Yes, there would be additional hoops to jump through potentially for an enforcement of a judgment, and those are not those won't apply if you're enforcing an arbitral award. But there are some downsides to arbitration versus litigation. So and vice versa. So, for example, the benefits of arbitration are that it's obviously the enforceability, but also it's confidential. It can potentially be more flexible, but it can be disproportionately expensive, particularly for smaller disputes. Although there are some organisations, and increasingly I think we'll see more, that have come about specialising in smaller disputes. But there's also very limited disclosure in arbitration, which could obviously be good or bad depending on what side you're on. And there are limited avenues for appeal. So I think that all needs to be considered in the round. Enforcement is very much not the only consideration. And if you do go for arbitration, then the choice of institution, the structure of the arbitration, and the seat should be very carefully considered alongside the governing law.
Thanks, Nicola. I've also had a question about timing for issuing proceedings in relation to being caught under the old EU Brussels recast regulations. And that's come up quite a bit. And I attended a Law Society event the other day, and there was some discussion about that. The wording used was proceedings instituted before the 31st of December 20. And the thinking around that means that you should have issued and served proceedings to be under the old regime. So that was the thinking at that time. I think we also have to realise that a lot of the new provisions haven't yet been tested. So my take is that we will see a lot of satellite litigation on these so-called Brexit or anti-Brexit dispute resolution clauses, and I think we will see a trend in satellite litigation, as well as dealing with the asymmetric clauses, as Julia has said. Another question that's come in is in relation to agents and service, drafting a particular provision in the contract. What does that mean exactly? No, Rebecca, you've covered that. Can you take that one?
Yes, thanks, Donna. Well, if you're contracting with a foreign party, obviously there could be a point at which a dispute arises from that contract, and you are stuck with a situation where you have an issued set of proceedings, and you're now looking at what the rules are around service and thinking about how long that will take you to do and how much it would cost you to serve out of the jurisdiction. So when we say include a clause which provides for the service on an agent, what that is referring to is an easier route that's been provided for within the court rules, which allow you to agree a contractually agreed method with your counterparty, which would allow you to serve within England and Wales. So, for example, your contract with your foreign party, whether they're in the EU or elsewhere, would include a clause which essentially says that any proceedings served upon that counterparty are to be served at their nominated solicitors based within England, and then that would keep you within the jurisdiction, and you wouldn't need to pay money in serving out of the jurisdiction and spending the time doing that. It would be a quicker and easier process.
Thanks, Rebecca. One other question that's come up is, would it be possible to restate or rethink the jurisdiction clause in pre-2021 agreements? Well, of course, the answer to that is yes, but that's only if the other party is willing to alter the contract. So that is something we are seeing in terms of people asking, can they insert something else or restate? Yes, of course you can, but you obviously can't do that unilaterally. You will have to get the agreement of the other parties. I think that looks like all the questions that we've got time for. Thank you very much for listening today. Unless the panel has anything else to add to our discussion, and as I said, I would ask you to look at the decision tree, which will be in our slides. We will send these to all of you that have participated and joined us today, and you do have our contact details if we haven't had a chance to answer your question or you think of something else. But thank you very much for listening.
Thanks.